Hello, I am delighted to be with you, to have the opportunity to speak with you about data privacy and cybersecurity issues. My name is Lisa Sotto, and I chair the privacy and cybersecurity practice at the law firm of Hunton Andrews Kurth. This really is an incredible moment in time to be speaking about these issues when these are not at this moment issues of Byzantine regulatory law, but in fact very real and operative issues in today's environment, often front page news. So let's dive right in and we'll talk about what the landscape looks like in privacy and cybersecurity law. So starting with some definitions, what's the difference between privacy and security? They're often meshed, they're often considered to be one and the same, but in fact, we should tease them apart and we need to think about them as different concepts, but really two sides of the same coin. So privacy is the appropriate use of data, and this is defined by societal norms. We see, for example, different ideas about what constitutes data privacy in Europe versus the United States versus certain jurisdictions in Asia. And so it's almost a grassroots movement that defines what privacy is in that society. And then once we have defined that as a society, those expectations find themselves then encoded into law, into statutory regimes in the various jurisdictions. Data security is the more objective side, where privacy is subjective, and individuals sometimes think about privacy differently. Security is quite objective, keeping data safe, making sure that data is kept confidential, making sure the integrity of data is not altered in an untoward sort of way. So let's start with privacy and talk about what the privacy regimes look like all over the world. Starting with, why is it important? Why do we think about data privacy at all? And what are the risks that we consider when we're thinking about privacy? So of course, from a business perspective, when we're thinking about privacy issues, we think first about legal compliance. We need to make sure that we're complying with the law in whatever jurisdiction we're doing business in. Now, that's sort of baseline, of course, but what really is even more critical in this area is reputational risk, because if you don't do things right with respect to a data privacy framework in your company, then you are really risking your reputation as a company, and the issue that you're dealing with could be a make or break issue for the business. Investment risk is where you invest in a new technology, you invest in a new initiative, a new business, and you find that you can't use the data from that business, that technology, that initiative in the way that you thought because of either legal compliance issues or reputational risk associated with that data. And reticence risk is sort of the flip side of that. And we think about reticence risk. This is an informal term, of course, but it's being afraid to use data in a way that you can bet your competitors are doing. So you're going to ultimately fail in your business mission if you don't use data. So it is critical to be able to use data, but you have to do it in a smart way. So how do you do that? To think about use of data in a smart way, we think about privacy by design and by default. And that means building in privacy from the start, not retrofitting for privacy concerns, but building it in, baking it in from the start of an initiative. We have what we're going to see in subsequent slides. We have a cacophony of laws globally around data privacy, and that really mandates that you have a framework in place within a company that will make sure that data is baked in from the start. And we need to think about it through every phase of the life cycle of an initiative. And of course, trust is absolutely critical when you're rolling out a new product, a new business, a new technology, and therefore data privacy can't be flubbed. You've got to get it right the first time. There's also a new focus on data ethics and data discrimination, and we're going to be seeing a lot more of that going forward. So that's also an interesting new framework, new lens really to think about data privacy. So we can see by this map that there are comprehensive data protection laws in many jurisdictions globally. The blue shows you where there are omnibus data protection laws in place. Red shows where there are efforts to enact those laws. And white, interestingly, shows no data privacy laws. This is, by the way, a map that's drawn from the perspective of a UK academic. And of course, something very glaring in white is the United States. So we see in the US that we are viewed as having really very few data protection laws in place. And of course, we do not have a comprehensive regime for data protection in the United States, although I would dare say that that's coming. These are the principles that we often see built into data privacy laws globally. Fair processing, we will process your data in a way that's fair, that's equitable to the individual. Collection and purpose limitation, we won't use the data, we won't collect data that we don't need to collect for the purpose for which we're collecting it, and we won't use it for any other purpose. Individual rights are ubiquitous now. We're seeing individual rights really built into every data protection regime globally. Those are typically rights of access, the right to access one's own data, the right to delete data, also known as the right to be forgotten. Also potentially the right, in some jurisdictions, the right to block your use of data. Data integrity is about maintaining the accuracy of data, making sure it's up to date and current. Data minimization speaks for itself, not keeping data that you don't need. And that's now very typical to see in comprehensive data protection laws globally. Service providers often need to be managed as well. Service providers really have very significant, in some cases, access to data, and therefore it's important that they be bound to contractual requirements to manage data in the way that you would expect. Data security, making sure that data is secure, kept confidential, and not subject to unauthorized access or acquisition. And of course, with any statutory regime and any framework really at all to ensure compliance, you need enforcement and redress opportunities. So what does the global landscape look like? Certainly, we are living in the information age. This is the era of digital everything, as you can see, because I was supposed to be there live yesterday, and instead I'm taping digitally. So we are squarely in the information age, and really, I think, catapulting even more squarely into the digital era now. We are grappling with these issues globally. These are not easy issues, not easy to embed in law the requirements that would service an entire society around data privacy. But every single first world country, other than the United States, every single one has a comprehensive data protection regime in place. We're the only ones in the US that don't. And many second world and third world countries have them as well. So we are absolutely out of step in the United States. Now, some of these regimes are reasonably new, others are more mature. But what we're seeing now is a real step up in enforcement. So there are much heftier fines being levied against businesses that don't do the right thing vis-a-vis data protection. And there are also other remedies like not allowing entities to use data in the way that they thought they could that are being enforced against companies. Now, as I mentioned earlier, the approach to data protection really is very much a function of the country's historical experience, cultural experience. So think about the fact that European data protection law is among the oldest in the world and also the most extensive, expansive in the world. So why? Because data was used in the Holocaust to put people to death. Here in this country, we market people to death. So there's really a very different experience with the use of data, where it was really used for very, very nefarious purposes in Europe, in some Latin American regimes, in other places in the world as well. Here in the United States, we don't have that historical experience to bind us to an understanding of malicious uses of data. It is very important. Most companies operate globally now, so it's very important to consider the global landscape when thinking about data strategies. As I said, regulatory approaches tend to differ. In the US, we have what is absolutely understood as a patchwork quilt of regulation, and we'll talk a little bit about what's in place in the United States. But I do think that change is coming. I do think that we are on our way to seeing a comprehensive data protection law in the United States. That is something that I would have expected to see around 2021, 22, but all bets are off in the current environment. So we'll see when that comes. But I think we're certainly going to see it in the next few years. California has been a leader in this area. In California, there is now the California Consumer Privacy Act, and it is a comprehensive privacy law, but it's only for Californians. In the EU, we see a comprehensive data protection regime. There are very expansive requirements. There are rigid obligations with respect to the processing of personal data. And many countries around the world have now mimicked European regimes in creating their own statutory frameworks that look very much like the European General Data Protection Regulation, which we'll talk about in just a bit. So it is very important to understand the global landscape when you're thinking about data protection strategies for an organization. So what's happening in the United States? In the US, we are known to have a sectoral regime, meaning we regulate privacy by industry sector. So the Federal Trade Commission Act is regulated by the FTC, the Federal Trade Commission, which prohibits unfair or deceptive trade practices. This is Section 5 of the FTC Act. And this Section 5 was enacted over a decade ago, over a century ago, when data privacy was not anybody's consideration, of course. But the law has been used in recent years to regulate data privacy and data security. The Gramm-Leach-Bliley Act regulates privacy and security with respect to financial institutions. HIPAA, you've all seen HIPAA notices every time you go to your doctor or you use a new pharmacy, you'll get and will need to sign off on a HIPAA privacy notice. HIPAA applies to healthcare entities as well as their service providers, which are known as business associates under HIPAA. One of the earliest privacy laws, although we didn't think of it as that at the time, is the Fair Credit Reporting Act, which applies to consumer reporting agencies and those who use consumer reporting agencies, and really all businesses do, for example, to get background checks on personnel. CAN-SPAM is one of the more recent privacy laws in this country. It regulates the sending of commercial email. The Video Privacy Protection Act, and you can see this is what I mean by certain industry sectors. So the Video Privacy Protection Act was passed actually in the wake of the nomination of Judge Bork for the US Supreme Court. And those who opposed his nomination pulled his video rental records. And these were, this was the old days. This is where video rental records were held by companies like Blockbuster Video. So the VPPA was passed in the wake of his failed nomination for the Supreme Court. And then similarly, the Driver's Privacy Protection Act also was passed in the wake of a harm. Here, there was an actress who was stalked by a high school sweetheart who found her Social Security number through a private investigator at the Department of Motor Vehicles, was then able, therefore, to find her place of work and murdered her through the use of DMV records. And so in the wake of that came the Driver's Privacy Protection Act, which now protects data held by state DMVs. The Telephone Consumer Protection Act, we all know as preventing some measure of telemarketing. If you are not on the Do Not Call registry, I would commend you to it. It's very useful in limiting telemarketing calls. The Children's Online Privacy Protection Act, COPPA, prohibits the collection of data from children online without jumping through various hoops. So there are lots of rules around the collection of data from kids online. And finally, I'll note the Privacy Act of 1974. That was passed in the wake of Watergate. So a real federal emergency for our country. And again, in the wake of a harm, we see a privacy law passed in 1974. And this actually formed the basis for many of the laws that were passed overseas much later. But we sort of stopped at 1974, and we didn't do anything after that until much, much more recently. At the state level, there are many, many privacy laws in place, really hundreds of privacy laws. The most important of which right now is the California Consumer Privacy Act, which just became effective in California on January 1, 2020, and the enforcement deadline is July 1, 2020, so that's coming up. It is a comprehensive privacy law for Californians, and it requires that organizations provide consumers with the right to access their data, the right to delete their data in some circumstances, the right to opt out of the sale of their data, and also requires certain privacy notices, which is why you're seeing on a bunch of privacy policies, California sections, just to deal with the CCPA. There are in 3 states laws that restrict private organizations from collecting biometric data. These are Illinois, where there's a private right of action allowed, Texas and Washington. Texas and Washington do not allow private rights of action, and it's only the Attorney General who can bring actions. But there was a very expensive settlement recently for Facebook for $550 million for their alleged violations of the Illinois biometric law, known as BIPA. There are laws that require privacy notices on websites. There are many, many health privacy laws in the states. There are also laws that restrict the use of Social Security numbers. There are laws that restrict marketing, for example, telemarketing in various states. There are other types of laws that prohibit the sharing of data for marketing purposes. For example, another law in California known as the Shine the Light Law is the example of this one. There are child protection registry laws, specifically in Michigan and Utah, RFID laws, and many others. I'm not going to go through them. I just want to note the last one, the last bullet here. There are now in many states data security laws, and it's very, very difficult to regulate data security at the state level because you can't really mandate a set of security requirements in a particular state when your data is going everywhere, not only every US state, but also moving globally. And then on the data breach notification side, there are 54 data breach notification laws in the United States, 50 states plus 4 jurisdictions, Guam, US Virgin Islands, Puerto Rico, and the District of Columbia. All right. So I said earlier that we are really looking at more legislation, and this is a map that it's a little bit dated now, but it gives you the idea. There are bills that have been introduced in many states in the US and are well on their way. I'll note that the Washington state law actually died not too long ago, a couple of weeks ago. So that's no longer in play, but the other states are in play. And then there are some others that have more recently come to the fore. So we are seeing an explosion in the states of privacy law bills that look like the California CCPA or like the European Union's General Data Protection Regulation. There's also been a real uptick in enforcement in the privacy area. So we've seen some very, very expensive settlements like the Facebook settlement for $5 billion, and absolutely an eye-popping amount. In addition to the biometrics settlement that I mentioned earlier for 500 plus million. The Facebook settlement is very interesting because not only was there this eye-popping fine, but also a requirement that the company change its governance structure around data privacy, so that there's a real change in how the company frames data protection within the organization and whose responsibility it is to do that. So there is now a requirement to have a board committee that focuses only on privacy. There are also reporting obligations for senior executives in the company to various government agencies. You can see some of the other really costly settlements here. Equifax, 700 million. And then some settlements also in Europe, like the Information Commissioner's Office in the UK settled in 2019 with British Airways and Marriott for significant amounts. And then there were some other settlements in Europe, like with the French Data Protection Authority and the Italian Data Protection Authority. And once that CCPA enforcement deadline arrives in California on July 1, there is no doubt that the Attorney General in California is going to be actively enforcing that law. So what we're really seeing is the need for global convergence, because there are many, many different laws around the world, and this really does lead to disharmony globally in how organizations manage their data. So we really are seeing the need for organizations to put in place frameworks that work for the organization, that are protective of data privacy. And that will get you, if you have a good framework and compliance program in place, that'll get you probably 80% of the way there with respect to compliance with the variations on the theme in global laws. All right, let's hit on cybersecurity. Let's talk about the landscape there. Well, it's no surprise to see all of these logos. These are companies that have been hit with very well-known cybersecurity incidents. And WannaCry and NotPetya, not an incident, but well, an incident that hit hundreds of thousands of. These are two different incidents of ransomware that hit hundreds of thousands of organizations. So, you know, what this slide really shows is that no industry sector is immune. We see financial institutions, social media companies, hospitality companies, restaurants, healthcare, retail. So just about everybody, every industry sector is represented here, and no one is immune to this risk. So what are we seeing today? We are seeing a very, very active cyber threat landscape. Bucketing the threat actors, what we typically bucket the threat actors into three buckets. First are traditional hackers. These are, this is typically organized crime. These are folks who are going after data for pecuniary gain. They're taking data and they're selling it, typically on the dark web. And this is a very lucrative crime, of course, and one with very little risk of prosecution, because these criminals are located all over the world, and there is often not extradition, most often not extradition in place for these criminals. We're also seeing nation states very active in this area, and so often Russia and China, lots of cybercrime also coming from Iran, from North Korea, of course, Vietnam, and lots of other places. So these are nation states that are very active in the cybercrime arena, that are doing their traditional spying. You know, every nation state spies, but this is a new venue for it. And often, in addition to sort of traditional spying activities, there's also theft of intellectual property and other data that is very meaningful and useful in the jurisdictions that are stealing that data, but of course very, very harmful to those whose data is being stolen. And then the third bucket is hacktivists. These are folks who are essentially anarchists who are banding together for one reason or another, like animal rights or some environmental activists sometimes, or others for really nefarious reasons, banding together and causing harm, like pulling down a website through a DDoS attack for some period of time, or doing what is also known as doxing. This is on the last bullet on this slide. Doxing is essentially pulling information from various public sources on the web and making threats against an organization, typically against a senior executive, to say, for example, to a senior executive, we know your daughter is vacationing now in the Dominican Republic, and if you don't stop animal testing by Friday, trust us, we know where she is. So they don't quite cross the line typically into direct threats, because that is a crime, but that's sort of a threat, sort of skirts the line, and it's in the gray zone. So there may not be prosecution for that sort of an email, but it's very scary for the executive who gets the email, and will often then have a security detail on the family of the CEO and on the CEO herself to ensure that nothing is translated and no harm is translated from the virtual world into the physical world for the CEO and her family. What data are they going after? Of course, we see that the threat actors are going after personal data, social security number to commit identity theft, financial data to cause financial fraud, medical data. There's a lot of medical fraud now. And really anything else that can be used for attacks, like even email addresses and mobile phone numbers for phishing sorts of attacks. Sensitive business information also is very much a target of cyber criminals. They've used the data to trade and in some cases really make a fortune on the use of sensitive business information. We're also seeing attacks now quite rampant in cloud environments, like in AWS and other cloud environments, often as a result of misconfigurations of the individual repositories of organizations. And we're also seeing source code being stolen as well. So what are some of the threat vectors that we're seeing? We're seeing just a ton of credential stuffing. This is essentially credential recycling, taking data that can be purchased for a song off the dark web, like a name along with my credentials, my password, my security Q&A, and using that on other sites, because chances are that I have used the same credentials elsewhere. We all fall prey to that. We're victims of our own misfortunes there. But it's very common that people use credentials over and over. And so you buy credentials that were stolen off of one site, try using them on another, and more often than not, the cyber criminals are successful. Of course, we're seeing just a huge amount of phishing. And if you send a phishing email to 50,000 people in an organization, you can bet that one of them is going to click on the link sent with the phishing email, give away her credentials, and there you are. You now have a criminal in your system unless you have technical backstops to prevent that sort of activity. We continue to see brute force attacks into systems. And of course, as I mentioned earlier, vendors and suppliers are a huge source of vulnerability. They often have authorized access to our systems. So for example, they are often given credentials to our system. So we can have a fortress around our own organization. And unfortunately, the bridge is down to these vendors, and they can walk right across the alligator-filled moat, across the bridge into the fortress, and there they are. If a criminal has gotten into the vendor's site and credentials that bring them into your environment, then your environment has been compromised. We're seeing a ton of business email compromise. This is where cyber criminals get into the email accounts of employees and steal credentials like wire transfer instructions and the like, or get in the middle of a discussion between two entities. And one says, I'm about to wire $1 million to you to pay you for your services. And then an email comes back and says, oh, great, I'm just changing the wire instructions. Can you instead use these wire instructions? And of course, the amount goes to a fraudulent account, and the money is withdrawn immediately as soon as the money hits the account. So there's no hope of recovering that amount unless you find out about it in the first 24, maybe 48 hours. Then you can stop the fraud because the money hasn't hit the fraudulent account yet. But after that, the money is gone. Cyber extortion. We're seeing a ton of cyber extortion as well. This is where there may be an email that comes in that says, we have 15 million of your records and we're going to expose them if you don't pay us 200 Bitcoins. Or we had a ransomware attack recently that was for 25 million, the equivalent of 25 million in Bitcoin. So to get the decryptor to be able to unlock systems. So ransomware is absolutely rampant, really, really prevalent, and doxing I mentioned to you earlier. Some interesting statistics here. So I'll start with the last statistic. The median number of days that a cyber criminal is sitting in systems until they are identified is 78 days. So if you translate that to the physical world, think about a criminal sitting in a basement bathroom in your house and being able to stay there for 78 days undetected, looking around for the first few days, and then stealing one piece of silver there, one computer here, and other valuable information in the case of the cyber world, or physical goods in the case of the physical world. So 78 days sitting in the system undetected is the median number. We are not finding these ourselves in many, many of these cases. In fact, in 41% of cases, victim organizations were notified externally that there was a cyber criminal in their system. Meaning the FBI called, or consumers reported fraud, or possibly one of the card brands called to say, we're seeing you, Acme Company, as the common point of purchase for fraudulent activity. So we think that there's something going on in your systems. We're only finding these events internally ourselves 59% of the time, and 64% of victims who have suffered a cyber attack will suffer another cyber attack, 64% of the time. It's really an extraordinary statistic. So what rules are there around data security? At the federal level, we have the same sort of patchwork that we had when we were talking about data privacy. We have the same sort of patchwork in the security arena. Again, the Federal Trade Commission Act regulates any unfair or deceptive trade practices with respect to consumer personal information. Similarly, in the financial sector, the Gramm-Leach-Bliley Act has both a privacy rule and a security rule known as the Safeguards Rule that requires financial institutions to put in place administrative, technical, and physical safeguards and to put a comprehensive data security program in place. The same is true under HIPAA and its amendment, the High-Tech Act. For health data, those who are subject to HIPAA, which are healthcare providers, health plans, and healthcare clearinghouses, need to put in place both a privacy program and a security program to protect health data. The SEC has rules around cybersecurity disclosures of issuers. There is also a law, CISA, that allows for some liability protection when companies are sharing data both with each other, so private to private information sharing of threat information, and also sharing as between the private sector and the government with respect to cyber threat information. And then there are very specific rules, for example, in the electric sector, the nuclear sector, and telecom sector, and other sectors as well. These are just some examples. At the state level, there are myriad data security laws. I've listed some of the states here. But again, this is a very difficult issue to regulate at the state level because we really can't put in place prescriptive security requirements in one state when data, in fact, is moving state to state. And this very same data set may be sitting in many states or in many countries, in fact. There are, as I said, 54 state data breach notification laws in the United States. This set of laws may, in fact, have been the most influential, the most important in regulating, in persuading companies to really put very significant security safeguards in place within organizations, because nobody wants to be the company that stands on their rooftop and raises a red flag and says, yep, we've had a really significant data breach. So these laws have been very influential in sort of naming and shaming companies to put stringent security programs in place within their organizations. There are also laws at the state level that regulate security for financial institutions, for insurers, and other industry sectors as well. There are now actually 2 states that have requirements for security with respect to the Internet of Things. California does, and Oregon as well. These are laws that require protections around connected devices. And in 3 states, there are now biometrics laws that protect the use of biometrics like facial geometry, hand geometry, fingerprints, and the like. And then there are also industry standards that are very important. There is a federal cybersecurity framework. It's a voluntary framework, but it's very influential. And in fact, it's really hard to get cybersecurity insurance without being in compliance with the NIST, National Institute for Standards and Technology, cybersecurity framework. The payment card industry data security standard has been a very important standard for merchants to ensure that there is security put in place around their point of sale systems, around the collection and protection of payment card data. The PCI DSS payment card information data security standard is mandated by the major card brands and applies to merchants that hold payment card data. ISO has a very important set of security standards, as well as does the Center for Internet Security. The top 20 security controls has been adopted by many organizations now. You can take a look at the CIS, Center for Internet Security, top 20 controls, very influential set of controls. So what are some of the trends that we're now seeing in the regulatory and legislative arenas? We are seeing US data security laws continue to evolve. I testified last year at an FTC workshop on data security rules in the US, and there was absolute agreement among all the expert witnesses about the fact that we have a paltry regime in the United States around data security, and that this sort of patchwork approach that we take in the US is just not enough. But we are seeing more detailed and prescriptive rules at the state level. So there is some hope for some of the models that we're seeing at the state level being adopted at the federal level. Hopefully that will come over the next few years. The scope of what is protected is expanding. So we've thought about personal information for years and the protection of personal information, but now we're starting to see laws crop up at the state level that require the protection of confidential business information as well, and connected devices, the Internet of Things laws that we talked about on the previous slide. There are also some laws that put in place safe harbors and liability protections. If you put in place certain standards that are enumerated in these laws, certain security frameworks, then the law will protect you from liability. And so there is real incentive to put these various safeguards in place. We're also seeing a heavy focus on accountability mechanisms. So boards are now in many of the security settlements with the settlements that companies have reached in settling lawsuits or settling liability claims, enforcement claims, again, with the federal government. We're seeing oversight mechanisms and reporting mechanisms being embedded into these settlements such that the board or the CEO or other senior executives need to report on their security frameworks and on their any security incidents to the federal government, to state governments, or to other regulators. So a lot of reporting and real responsibility now from the top is totally expected. So 2020, where are we now? We see this patchwork of data protection laws around the world that really is mandating that organizations take a global approach to managing their privacy and their security frameworks. As I said, the US is really out of step with global developments in this area. And I think really Cambridge Analytica created this line in the sand because we were not, as a society, deeply aware of how our data was being used by organizations until Cambridge Analytica. And then I think there was a real societal shift, and people started to really understand that their data was being used in ways that they didn't fully comprehend. I do think that privacy will continue to be a key issue in the 2020 presidential election. Of course, that's gotten quite derailed by other events. But I briefed two presidential candidates in 2019 on privacy and cybersecurity issues. I think they were very conscious of the fact that this would be a significant issue in the upcoming election. So I think we will see it rise to the fore, although it may be superseded now by other events. And certainly consumers are very well aware of their rights in the data privacy arena, and are, often appropriately outraged at how insecure certain organizations are when it comes to maintaining their data when they've trusted the organization to do the right thing with respect to data. They've entrusted the organization with their information, and these organizations sometimes are not keeping the data secure. So, you know, what would I predict? Certainly in the next decade. I hope sooner than that. I hope I can say 3 to 5 years. We will have a comprehensive privacy law in the United States. And we may, in fact, have a different agency other than the FTC put in charge of privacy. There have been some federal proposals along these lines. There was a bill in 2019 that was proposed to create a separate federal agency to govern data privacy and data security. I will say personally, I think the FTC is doing a very good job. They have a huge amount of experience now, and their division of data privacy, and it's the DPIP division, data privacy and I can't remember what the IP is, information protection, I think, data privacy and information protection. But the DPIP division is very, very strong, really quite expert at managing data privacy and security investigations and enforcement at the federal level. So additional predictions. We as a society in the United States are only going to continue to be more respectful of and have a greater comprehension of our privacy rights. So there will need to be a concomitant change by organizations to ensure that they're responding to those individual privacy protections as perceptions as they continue to grow. We will also, of course, see many developments on the artificial intelligence and Internet of Things front. So as these AI and IoT continue to evolve exponentially, we will also see related privacy and security protections that need to come into play when thinking about AI and IoT. Blockchain is also going to be a very important development over the next few years, and of course, absolutely depends on security around blockchain technology. Very, very important to make sure that that security is in place, or the blockchain will fail. Biometrics, boy, we're going to be seeing a heck of a lot more around biometrics now, certainly with we've already seen a lot of action around facial recognition, for example, use of hand geometry, fingerprints, use of retinal images and iris images and the like. But we certainly are now going to be focused on body temperature, and there will be, I would imagine, major pushback around that until we have good privacy protections in place, and security around that data is absolutely a baseline consideration. So the key to all of this is to be judicious in your use of data, think about consumer trust, and think about the protections that you have to put in place in order to maintain that trust. On the cybersecurity front, the level of sophistication of the cyber criminals is very, very high. They're really good at what they do. And they are continuing to surprise us daily. We've handled, in my group, 1,700 or 1,800 data breaches over the last few years, and we are seeing just incredible sophistication in the types of exploits. The level of exploits, really the ability of the threat actors to get at data in ways that we could not even have predicted. And they are deleting their tracks. So it's getting more difficult to even detect their activity because they're coming back and deleting their footprints in a system. So we should absolutely expect more and more serious attacks over time. And it's going to be much more important for every organization to have the backstop of cybersecurity insurance in place, because these attacks are going to get more and more expensive to manage. The timing of notification has also changed. It's very important to quickly, when we see within businesses something untoward, something happening, we have to pull together our incident response team quickly and quickly bring in a third party to do a forensic investigation just as soon as we see untoward activity. And of course, our customers, our employees, and other individuals whose data we hold as organizations are more and more sensitized to these sorts of events and expect that they will receive notification very quickly. If we fail to do that, we will fail in their eyes, and that is a recipe for disaster within an organization. Social media has really changed how we manage these events. It used to be that traditional media was a little bit slower. We didn't have to respond quite so quickly, but you can bet if something is happening on the cybersecurity front within an organization, folks are going to find out about it, and social media will come into play and will need to be managed very, very quickly. We are seeing very significant fines and enforcement in this arena. Regulators are all over these issues. And I think this last bullet is so important. The focus on cybersecurity issues absolutely has to come from the top. Every organization is now recognizing this issue as a governance issue, a fundamental risk issue for the organization that needs strategic focus from the very top of the organization, from the board, from the senior executives within an organization. So I will end there. I would welcome questions by email. Here's my, my information, and I am delighted to have had the opportunity to speak with you about data privacy and security issues. I hope to do it live at some point, and I am truly very happy to hear from you, and would be glad to answer questions by email. Thank you so much. I appreciate the opportunity to have spoken with you today.